So I just wanted to start off by acknowledging the traditional owners of the land on which I'm speaking from you today, the Wadawurrung people of the Kulin Nations, and pay my respects to their elders past, present and emerging. I also want to acknowledge and thank Kayleen for her effort and hard work putting together this fantastic program about legal challenges for a cyber-physical world. Finally, my co-authors, Michael Wilson actually worked on this project as our research assistant prior to landing a level B lectureship at Murdoch, and Dr. Ian Warren, who is similarly a senior lecturer in criminology with me at Deakin. So just as a bit of a background, next slide. I've got someone controlling the slides for me. So a bit of a background and outline for what we'll be talking about today is IoT for children, the surveillance of children, children's rights, the role of parents and guardians. The framing of our research aligns with the concepts of privacy literacy, digital housekeeping, and data justice. Then I'll present the methods and results of the empirical research that we conducted. We conducted a survey of over 1,000 consumers and non-consumers of IoT devices. And then I'll reflect upon the significance and contributions of this research, and then start to think about, well, what does this mean in terms of regulatory implications, because I know that that's very much an interest to many of the people attending this symposium. Next slide, please. Thank you. So just as a background from where this project has come from, or this paper has come from, it was an element of a larger project funded by the Australian Competition and Consumer Action Network, ACAN, that we delivered last year, myself, Ian Warren and Dermot Harkin. And this project examined consumer awareness of privacy in the Internet of Things. So that report is available online. You can just Google it and access the report online. And as part of that report, or as a part of that project, I was really interested in looking at aspects as related to children and also other vulnerable members of the community. Ian in particular was very interested in looking at impacts of IoT on renters, another sort of vulnerable group as well. And so this opportunity within the ACAN grant more broadly enabled me to include questions in the surveys and interviews, specifically in relation to children's privacy. We also developed a whole range of consumer education resources, including a series of icons, and the one that's on the slide here is the one that related specifically to child privacy or children's privacy. In addition to the published report that you can access on ACAN's website, we've also published very recently an article in the journal Policy and Internet concerning consumer IoT and its under-regulation, so you may find that of interest. And the paper that I'm presenting today has also been published in the International Journal of Children's Rights, and we have a series of other articles at various stages of development as well emerging from this project. Next slide. Okay, IoTs and children IoToys. So I'm sure we've been speaking about throughout the conference, or more broadly, the Internet of Things and how they encompass a growing range of devices that connect to the Internet and also to each other, and how this enables or forms a digital ecosystem in various environments, including the home and domestic contexts. Significantly, and I think this came from the Okola report, IoTs in smart homes constitute almost half of all machine-to-machine ecosystems. Significantly, IoToys, Internet of Toys, and other devices that monitor children are an expanding subset of the IoT market. And both the Internet of Things and the Internet of Toys present enormous challenges for human rights, including but not only that of privacy. And these challenges are especially pronounced for children. And this is because the implications of ubiquitous corporate surveillance that occur across a child's lifetime and within the context of private homes really requires great understanding in terms of the role of privacy as a protective mechanism, and also parental responsibility in terms of protecting their children's privacy also. Next slide. All right, so from the field of surveillance studies, which is where I tend to situate myself as a surveillance scholar, there's a body of work in relation to the technologically watched child and children as subjects and agents of surveillance. Deborah Lupton, one of your UNSW colleagues as well, has been writing on the datification of children and specifically through IoT devices. And she argues that this, very much normalises corporate surveillance of children through the collection of their spoken words, video recordings of their activities, and their biometric data that documents their growth and physical health, in particular, before they're even born and also during their formative years. And this can also enhance exposure to a range of additional harms, so potential unwanted intrusions by dangerous contacts. We've heard of the case studies of people talking to children through baby monitors, for example, not their parents, that where they've been hacked, unsolicited digital marketing, commercial profiling, and a host of other security risks. So these types of hazards also intersect with related harms associated with predictive analytics that can also undermine children's privacy and over the course of their lifespan. So ultimately, the specific risks and harms that may emerge from the Internet of Things and the Internet of Toys really depends on the specific context of their use, and they can be quite broad and varied. Next slide, please. All right. So in terms of children's rights, and I just wanted to emphasise here that rights-based approaches are not necessarily a remedy, as we know, and they're also not necessarily in direct response to the development of technology. But in terms of this article and this research that we conducted, we've really focused on children's rights, for example, those under the United Nations Conventions on the Rights of the Child. So, for example, Article 16 of the UNCR stipulates that no child shall be subjected to arbitrary or unlawful interference with his or her privacy, family, home, or correspondence, nor to unlawful attacks on his or her honour and reputation. I'll come back and answer some of the questions in chat at the end, because I think it'll just be too much for me to do that while also presenting and keeping within the strict time limits, if that's okay. And then also noting that there are child-specific provisions in key international regulatory frameworks, such as the GDPR, which introduces enhanced requirements and protections for children's personal data. But within the field, there are debates between protection and empowerment of children. And that's something that I'll speak to when I present some of the empirical data, and we can talk about that also in the context of questions. So next slide, please. Also, in terms of the UNCR, Article 5 establishes that the child's right to receive guidance from parents, legal guardians and families, and the support that they have in exercising their rights under the UNCR. Further, Article 18 also sets forth that state parties shall use their best efforts to ensure recognition of the principle that both parents have common responsibilities for the upbringing and development of the child. Parents, or as the case may be, legal guardians, have the primary responsibility for the upbringing and development of the child. And so in terms of this trustee relationship in relation to children's rights, parents and guardians have a very important role in the preservation of children's rights, and also through the types of information technology systems and services that they purchase, that they set up, and that they use within the domestic context that the parents or guardians control. So what this means is that parents and guardians have both a legal obligation regarding their children's privacy, as well as practical responsibilities for determining the domestic environment in which children and technology coexist. And so it's in this way that we conceptualise, or we consider in this research, parents and guardians as trustees of their children's rights. And to date, very few studies have examined how parents and guardians view and enact privacy protections on behalf of their children, and specifically in the context of the Internet of Things. Next slide, please. All right, so this speaks to the conceptual and somewhat theoretical framing of the research. In terms of the research, we adapted Park's measures of privacy literacy to an Australian context, and we developed a privacy literacy scale that included a series of binary items, 2 subscales, that measured participants' knowledge of digital surveillance practices, so that was the surveillance awareness subscale, and also familiarity with Australian privacy law, that was the policy understanding subscale. So essentially, the surveillance awareness subscale measured knowledge of the scope of corporate surveillance, while the policy understanding subscale measured knowledge of privacy laws and policies. Significantly, The research on privacy literacy shows that privacy literacy predicts the likelihood that users engage in strategies of privacy protection. And previous research has consistently shown, for example, individuals with lower income and less formal education are less privacy literate. Older people and women also tend to have lower levels of privacy literacy compared to younger people and also men. And so this means that the privacy risks of using information communication technologies are unfairly borne by those with less material and social power. And given this, our argument in this paper was that therefore a normative model of data justice is one way that we could understand these inequalities of privacy literacies and their impacts. And this is because at its core, a data justice framework drawing from the work of Lena Densick and colleagues at the Data Justice Lab at Cardiff University is concerned with the unfair distribution of the costs and benefits associated with ICTs. And it's actually great to be participating in another seminar by Alan's Hub and UNSW Law and Justice, because I think this is probably like the third time I've participated in one of these seminars with an emphasis on data justice, but I know Janet Chan has been, primarily organising the others. Okay, next slide. One site of data injustice relevant in the context of IoTs and children's privacies and smart homes is the gendered distribution of technological expertise within domestic settings. And this is drawing on a range of Australian researchers kind of published work in this area as well. So, for example, Kennedy and colleagues described the labour necessary to maintain a networked home as digital housekeeping, and they observed that unlike traditional housekeeping, digital housekeeping is more likely to be performed by men. And they suggest that this is because the technological expertise required to set up a networked home is more likely to be valued and acquired by men. Similarly, Strangers and Nichols found that men tend to perform the digital labour associated with the establishment and maintenance of smart homes, including tasks such as researching products and systems, integrating, maintaining and monitoring multiple devices and systems, troubleshooting issues, educating other households or householders about how to use devices, and upgrading, updating or repairing software and hardware. So quite different to the gender distribution of, offline, non-digital housekeeping. So such issues, very significantly affect the governance of children's privacy in the domestic sphere due to the gendered imbalance in childcare responsibilities, because majority of this work continues to be performed by women. So you have a division here. Okay, next slide. All right, so overall, parents and guardians are a subpopulation of ICT users whose level of privacy literacy are influenced by a range of factors: income, educational attainment, gender distribution of expertise in digital housekeeping. But what further distinguishes parents and guardians is the additional influence and responsibility they have regarding their children's privacy and control over the domestic context in which children and technology coexist. So given the expanding scope of corporate surveillance targeting children through IoTs, and this responsibility we're placing on parents is appearing to be quite an onerous one, and this may have on a series of ongoing impacts and implications for data justice and for children's privacy protections. And so in order to explore these issues, we sought to address 3 research questions that are on the slide. What is the relationship between guardianship and IoT in IoT purchasing behaviour? How do guardians perceive their children's privacy? And what is the relationship between guardianship and privacy literacy? Okay, next slide. So I'm not going to go into the full details and method. You can access this from the published article. We describe our methodology, method, analytic strategy great length in that published article. So just essentially we ran a panel survey of 1,052 Australian adult respondents. We didn't survey children. That was beyond the scope of our project in terms of our funding from ACAN, and also would have presented a whole range of additional ethical concerns. So our sample consisted of 844 individuals who had purchased an IoT in the previous 12 months, and we also included a comparative sample of 208 individuals individuals. We collected, it was an extensive battery of questions in relation to socio-demographic information, ownership of specific IoT devices, child monitoring devices, home security systems, etc., measured levels of privacy literacy, children's privacy, and a whole range of other information that was relevant to the broader grant. We also asked if participants were parent or legal guardian of children that they live with at their primary place of residence, and that's how we operationalised being a parent, parenthood or guardianship. I will note that the major limitation of our research, and maybe this was an oversight because I myself am not a parent, but we didn't ask the age of the children, which would have some significant implications, I think, in terms of how parents were responding, because you would anticipate that these issues would differ for younger children compared to older children. All right, next slide. Research question 1. So what's the relationship between guardianship and IoT purchasing behaviours? Next slide. So we examined this relationship by identifying whether guardians and non-guardians were purchasing different IoT devices, or indeed whether or not they were more likely to purchase IoT devices at all. And so if a respondent reported being a guardian of a child, she or he was significantly more likely to report owning an IoT device compared to non-guardians. And this is significant because the fact that IoT device owners were more likely to also be guardians really reinforces the importance of a clear framework for the protection of children's privacy. And we did a series of chi-square tests, and they indicated that guardians were significantly more likely to have purchased 17 types of IoT devices more frequently than non-guardians. And as expected, guardians were significantly more likely to purchase smart toys, IoToys, and they were also more likely to purchase IoTs marketed for surveillance and security purposes, such as child monitoring devices, home security systems, smart doorbells, smart home locks. And in contrast, non-guardians were not significantly more likely to purchase any specific IoT devices. So that is our response to research question 1. Next slide. We next examined guardians' perceptions of their children's privacy, and across all items we asked in our novel perception of child's privacy scale, participants agreed or generally agreed with statements measuring concern for their children's privacy, and I will just run through some of these quickly now. Next slide. Over 70% of guardians indicated that they considered the impacts of IoT devices on their children's privacy prior to purchase. Next slide. Over 70% indicated that they avoided posting personal information about their children on the internet, also known as sharenting. Next slide. This was an interesting one. Although 60% of guardians also agreed that children should be able to decide what information about them is published on the internet, almost 24% expressed disagreement, which was more for any other item we examined in the perception of child privacy measures. And I think what we're seeing here is this tension that I spoke to earlier between empowerment and protection. And obviously here you would expect this mediating factor of the children's age. But as I also explained, the main limitation and the issue is that we just didn't ask the age of the children in terms of this research. Next slide. A slight majority of guardians agreed that IoT devices such as smartwatches are useful for monitoring the safety of their children. And in contrast, 40% of guardians were uncertain or neutral about the usefulness of IoTs to monitor child safety. Next slide. Guardians expressed the most agreement with items measuring concern about the behaviour of tech companies engaging in the surveillance of their children. Indeed, over 75% or 3/4 of guardians had concerns about technology companies collecting and storing personal information about their children. Next slide. And similarly, over 75% or 3/4 of guardians supported the statement that technology companies should be legally compelled to delete any personal information that they collect about children. So next slide. We then examined the relationship between guardianship and privacy literacy, which was our third research question. Next slide. So we found, in terms of our analyses, which was a series of t-tests and two-way ANOVA, we found that non-guardians performed significantly better than guardians on the privacy literacy scale. Non-guardians also performed significantly better than guardians on the surveillance awareness subscale, but there was no significant difference between guardians and non-guardians on the policy understanding subscale. And this suggests that any differences in privacy literacy are primarily explained by differences in surveillance awareness, which measures knowledge about the scope of corporate surveillance practices. We also tested for potential multivariate relationships to explore further the interaction between guardianship and privacy literacy. Specifically, we examined the multivariate relationship between privacy literacy, guardianship status, gender identity, income, and education. Our preliminary analyses, when we were conducting the model building, indicated that there were no significant impacts in relation to income and education, but there were significant main and interactive effects associated with guardianship and gender. So within our model, the main effect of guardianship on privacy literacy was significant, as was the main effect of gender on privacy literacy. And the interactive effect between both guardianship and gender was also statistically significant. And so I know that's a lot to take in and it's very confusing. I was actually excited doing this research because it's the first time since I did my psych degree as an undergrad that I was actually able to publish some like hard quant analyses as a diversion from my regular critical socio-legal research. But basically the figure on the slide visually depicts this relationship and highlights how guardianship predicts lower privacy literacy and specifically among women. Okay, so that's really important. So guardianship predicts lower privacy literacy and specifically among women. So given that women continue to provide the majority of childcare within Australian households, lower privacy literacy, also combined with the gender distribution of digital housekeeping, is likely to influence the ability for mothers to protect their children's privacy in domestic settings. And I hope here you can start to see now the relevance of framing this research within a broader data justice framework. As such, and what this means is that the protection of children's privacy cannot be decontextualised from social and data injustice, and it must be understood with regard to structural factors, in particular, gender discrimination. Next slide. All right, how am I going for time? Kayleen, can you give me any indication?
Sorry, I had it off and Bryony was giving us. Bryony, go ahead.
Almost at 22 minutes.
All right, I'll be really quick then through the rest in terms of the significance, contributions and regulatory implications.
But 8 minutes.
In essence, what this research shows is that Australian parents and guardians purchase IoT devices at greater rates than adults who don't have children. Our findings also show that parents and guardians are concerned about technology companies collecting and storing personal information about their children and support greater regulation of corporate child surveillance practices. Next slide. Our research also shows that female guardians tend to have lower privacy literacy compared to their male or childless counterparts, and this is consistent with previous literature that identifies how social injustices produce data injustices, including a discriminatory relationship in relation to gender and information communication technology. So the protection of children's privacy rights in the context of IoT must be understood with regard to these broader structural factors, and it also requires addressing the corporate practices that characterise the contemporary surveillance landscape. And I'm sure, and in David Lindsay's presentation earlier this morning, he had perhaps something to say about the notice and consent model, and I'm also going to speak about that now as well. Next slide. So in terms of the regulatory implications of this, so, we're talking about privacy literacy. You might think a solution is to enhance people's privacy literacy. Maybe, attempts to enhance the privacy literacy of any individual may help. Those programs or those types of attempts are likely going to be limited in protecting children from the privacy risks of IoT, simply because of the scope and the nature of corporate surveillance practices, and also combined with these broader social and data injustices that we're speaking of here. And so, in essence, what we argue in this piece is that the state is really the only actor that's able to effectively regulate, or potentially, maybe, we can have this conversation, I think, in question time, such corporate practices. And so specific reforms to enact this type of change can involve different degrees of regulation over the collection, retention, and use of personal information. So, for example, this could involve enacting additional principles within privacy laws to further restrict corporate surveillance of children based upon, for example, sensitivity of data, the purposes of data collection, and the rights of consumers to access details about data collection and also associated analytic processes. Such an approach could reduce the power difference between corporations and citizens, because there is this imbalance in terms of the power between individuals and corporations. But we don't think that this would be sufficient, particularly given or as long as notice and consent remains the accepted model for information privacy and corporate surveillance. And certainly we go on about this in the published ACAN report, and also in the article that we published in terms of consumer IoT and its under-regulation in policy and internet. So thinking about alternatives, privacy laws could perhaps embrace a model of implied consent, whereby the law strictly governs what data can and cannot be collected without the need for active consent every time information is collected, or when you click a yes, I accept notice and consent box. In theory, that could address some of the problems with consent fatigue, particularly for parents and guardians who are consenting on behalf of their children all the time, and standardised data collection practices for consumers, regardless or irrespective of their digital and privacy literacy, and that could address some data injustices. With that said, it remains incredibly difficult, if not impossible, to imagine an implied consent model that does not also create further opportunities for exploitation, unless the boundaries of acceptable data collection are made perfectly clear and or actually enforceable. So what this means, when we were thinking about the options more broadly about what we can do, and this is, a very challenging field, as I'm sure many of you are aware, we really kind of landed on, if the state wants to protect children's privacy, perhaps the best reforms, and this is very utopian, but I'm still going to say it, may require the decommodification of data, whereby commercial use is not an acceptable reason for the collection and retention of personal data, but then that would also ultimately require a reconceptualization of the internet as a public utility, rather than what it currently is now, a public space that exists primarily for data extraction. So that's kind of our thoughts on sort of where to go from a regulatory perspective. Next slide. So you can access the article. I'm more than happy to send it to you. You can also find it online. It was published just last month in the International Journal of Children's Rights, Smart Parenting, the Internet of Things, Children's Privacy and Data Justice. Next slide. Thank you. And I didn't hear the bell of doom, so I must be within my acceptable time limits.